Hello again. I'm Jo from Navistar Legal. Thank you for joining me. In this video, we're going to address some of the big clauses that you will want to at least read and understand, but ideally remove and negotiate when you're dealing with bigger businesses than you. This video is one in our contract and negotiation series, in which we've already looked at the risk profile of an agreement and some of the more important aspects to consider prior to negotiation. In this video, you can walk through a draft contract to work out which clauses you want to exclude or include in that specific agreement. We advise every business that we deal with to do everything on their own terms, but this is not always possible with large companies. Large companies expect to use their own terms, and sometimes you are just not in a negotiating position to argue with that. This can increase the risk for you as a smaller business, as when you're signing up with a larger business, particularly corporates, you may have one-sided agreements. The first thing to do is to identify red flags in their agreement. If this is a corporate, then you will find that everything is stacked in their favor, and unless you want to negotiate for 3 months, you are really not going to be able to change it very much as a small supplier. You may then have to just suck up the risk and accept that this is going to be a higher risk potential than another agreement. Once the agreement has been read, identify those clauses that cause particular concern. These clauses give a warning signal for the risk that you may encounter later on. Review, understand, and negotiate in these areas will mitigate some of the risks. We'll address the red flag clauses in more detail in our Affordable Legal Wisdom course. But for now, let's address a few clauses that we would ideally want removed or included. The ideal way of looking at this video is with a draft agreement in front of you. So let's start to look at some of the clauses that you will want to remove or ensure that you at least negotiate more fully. The first is the indemnity. So what is that? Well, an indemnity is a promise by a party, probably you, to compensate the other party, your big business partner, for any loss or damage caused by you or a third party you engage. It will say indemnify, defend, or hold harmless. If your company is expected to give an indemnity, then be clear, very clear about the types of actions or omissions you will compensate them for, the extent of the loss that you're prepared to cover, and then who bears the cost of those losses, which might include legal costs, damages, and other fees. Ideally, you'll want this entire clause totally removed, but unfortunately, many larger companies will expect to keep it in. As a result, you may want to ensure that you have insurance to cover any responsibility that you have under this clause. The second thing we're going to look at is payment terms. You may provide special discounts to larger companies, or generally because the money coming in is quite a lot of money, it's disproportionately large for you. So cash flow is going to be a higher risk. As a business owner, you quickly learn that cash flow is critical to business. And this is no more true than providing services as a small business to a larger corporation. You will quickly learn that cash flow does not always flow in the direction you would like. This may be your biggest client and your greatest opportunity. So of course it's so tempting to accept the corporation's payment terms without exploring the real cash flow consequences. They're going to argue with you that these terms are standard and cannot be changed, and you may come to believe that you don't really have any leverage or choice in the matter. But do remember that everything is negotiable, and more so important with cash flow. You want to focus and find the negotiation for the value with the corporation so that you can make those changes. Recently though, larger corporations are demanding an increase to their payment terms. This means it will take them longer to pay you. It's usual for payment now to be 128 days after you have provided them with their invoice. This recent change might be in consequence of lots of different things, including outsourcing payment services or increased pressure within the corporation to have higher cash reserves. But whatever the reason, it doesn't encourage healthy cash flow for you. There is this code, it's called the Prompt Payment Code. It's a voluntary agreement that intends to promote better payment practices in businesses. The code aims to prevent larger companies from changing the length of their payment terms for smaller companies if they're unreasonable. However, until the code is common practice, or ideally in legislation, getting a fair deal is going to be down to the contract that you agree. So here are some points that you want to consider when in negotiations. 1, sometimes you're going to have to set boundaries and refuse to go beyond them. 2, by completing an accurate cash flow projection, you can objectively determine where those boundaries lie and whether a contract actually works commercially for your business. 3, if they don't work for your business, then explain clearly that the payment terms will be detrimental to your cash flow and that new terms won't allow for a sustainable partnership in the long run. Ask them to work with you to find a suitable solution. Next clause we're going to look at is force majeure. It's the first clause that you will definitely want to consider and add into the contract if it's not in there already. A force majeure clause it enables you to restrict your liability and your obligations if something beyond your ability to change things comes into play. This could be an act of God. This will only temporarily stop you having to perform an obligation. But for example, if you're providing services to a customer, then you'll definitely want to include this clause. It will say, for example, the time that your obligations will be suspended or limited if this act of God occurs. For example, you can't get coffee beans from a country for political reasons. If this event does occur, then you will then need to let the other party know the reasons for the delay and the stoppage, and you'll have to take all reasonable steps to overcome the delay, but it won't be a breach of agreement. It's a seriously useful clause if you can get it included in an agreement. Then another thing to check is jurisdiction. International jurisdiction is complex, and I don't intend to give you a lecture on it here, but different countries have their own procedures and rules for disputes. And when you start working with someone in another country, it can be costly, including costs of transport of evidence, witnesses overseas, paying for local legal advice, and potentially extensive translation. If the contract doesn't allow for these 3 things, then it is certainly a red flag. The 3 things are: the language of the contract must be English, the law of England must govern this agreement, and the courts of England must have exclusive jurisdiction over the agreement. Little aside on international agreements: if your contract is not under the laws or courts of England, then unfortunately it's not likely that this big conglomerate will suddenly change this for you. It's not the end of the world, but if the agreement is significant commercial value to your company, or if there are significant consequences if the agreement is broken and the agreement is under another law or jurisdiction, you must engage a local lawyer to perform a review of the agreement. If you ask an English lawyer to review a non-English law contract, then they can only provide you with basic guidance based on the English law customs. They are unlikely to be able to pick up the intricacies of the law in another country. For example, in the United States, each state has different laws and different requirements for their admission to the bar. Therefore, a Californian lawyer will not be able to comment on a New York legal agreement and vice versa. Another clause that is absolutely critical for a service agreement is a limitation of liability and an exclusion clause. Limitation of liability operates to limit the amount of the damages you would have to pay to another party or the amount that they can recover from you. An exclusion clause seeks to prevent the other party from recovering damages altogether in certain situations. If you're providing services to a big company, you will definitely want to include a limitation of liability clause. Why is that? Well, if you do not have this clause in place, then you will be responsible for unlimited damages, which would mean devastating costs against you and rapidly increases your risks under the contract. Finally, if it isn't included, you may want to see if you can add an alternative dispute resolution, or an ADR clause, as it's known, to allow you to resolve conflicts in a more informal setting. It means that the dispute is kept confidential instead of being in public court proceedings, and that means that trade secrets will remain a secret. It's quicker than traditional litigation routes, which is important if your issue is time sensitive, and perhaps most importantly, it allows disputes to be dealt with more cheaply than going to court. It's less confrontational, and it's a great choice if you want to preserve a commercial relationship with the other party, which you probably will. So that brings us to the end of our series on larger contracts. I hope that you've received in this series an understanding of the power differences between the small and larger businesses, the clauses that can be included in the agreement, and those that you probably will want to remove. I wish you all the best with your negotiations, and I look forward to meeting with you soon.